Hello and welcome back to the panel this morning on our Human Rights in a Time of Populism conference. We now move to populism in Latin America. And my name is Yee Htun, and I'm a clinical instructor here at Harvard Law School's International Human Rights Clinic. Joining me on this panel are three distinguished panelists. Their full bios are in your conference booklet, so I'm going to keep my introductions short. We're going to start with the presentation starting from far right, coming to the person right beside me immediately. In the far right, we've got Dinah L. Shelton, who's the Ahn Professor of International Law, Emeritus at George Washington University. Next to her in the middle, we've got Alexandra Huneeus, who's an Associate Professor of Law and Director of the Global Legal Studies at the University of Wisconsin. She's a leading authority on human rights in Latin America with an emphasis on national and international courts. And last but not least, I've got Helena Alviar García, who's a visiting fellow here at Harvard Law School from the Universidad Los Andes, and is an expert on feminist approaches to law and relationships between law and development. So if you could take it away, Dinah.
Thank you. I'm going to actually start at the global level with one of the preambular paragraphs that actually stimulated me to pick this topic for my paper. The Universal Declaration of Human Rights implies the legality of revolution to overthrow a government in some circumstances. And I quote, "Whereas it is essential, if man is not to be compelled to have recourse as a last resort to rebellion against tyranny and oppression, that human rights should be protected by the rule of law." The initial commentary to the UDHR described the right to revolution as an instrument by which men might set up government in conformity with justice if the fundamental principles of justice and basic human rights are violated in such fashion as to permit no redress by recourse to peaceful means. So that was the starting point in 1948, that there was, as a last recourse, the right to revolution to overthrow governments engaged in violations of basic principles of human rights. The first treaty that was adopted after that was the European Convention on Human Rights, which said nothing about this, but the case law of the European Court of Human Rights very quickly recognized that political parties that were dedicated to repression, to instituting a system that would be in violation of basic human rights, could legitimately be banned. It was used first against the communist parties in Europe and then later against Islamic parties in Turkey. The inter-American system, by the time the convention was drafted, was in a position of being rather skeptical about the use of coups because there had been so many of them in Latin America by that point. In fact, the OAS itself only called once in its history for the overthrow of a government. That was in 1979, based on an Inter-American Commission report that found the Somoza government was responsible for the massive human rights violations that had gone on in Nicaragua. It said rather contradictorily that the solution to this problem lay exclusively in the hands of the Nicaraguan people, and then went on in that next paragraph to say, but it should nonetheless be based on the immediate and definitive overthrow of the Somoza regime. Everybody voted for that except Nicaragua itself and one other government, which was not the U.S. Despite the many violations of human rights that took place in the 70s and 80s on both the left and the right, that example was never followed again. They never called for the overthrow of another government. Later on, and much more recently, we've seen a lot of situations in which governments have been removed from power using impeachment procedures and prosecution of heads of state. Most recently, the president of Peru resigned after corruption allegations. That was preceded by actions in Brazil and a few years ago in Guatemala. What's interesting is that in all of these cases, there had been massive human rights violations throughout the years, but it was only corruption that brought the people to act to get rid of the head of state and others around them. It seems like you can violate human rights, but don't steal money from the people, because they will then respond. The biggest action in the OAS in this regard was the adoption of the Inter-American Democratic Charter. It was adopted on September 11th, 2001, which was why our Secretary of State was not in the U.S. when 9/11 took place. It does not entirely reject the possibility of extra-constitutional change, although it makes it presumptively illegal. Part 4 concerns the actions to be taken by the OAS in response to an unconstitutional interruption of the democratic order or an unconstitutional alteration of the constitutional regime that seriously impairs the democratic order in a member state. That seems to imply that there could be unconstitutional alterations of the democratic order that wouldn't seriously impair the democratic order in a member state. It calls such actions an insurmountable obstacle to the government's participation in the organization. According to Article 20, any member state or the Secretary General can request a meeting of the Permanent Council to assess the situation and take such actions as it deems appropriate. Pursuant to Article 23 of the Democratic Charter and Article 9 of the OAS Charter, the Assembly may, by a two-thirds vote, suspend the participation of the state in question. In practice, the Inter-American Democratic Charter has been invoked against Venezuela twice, Bolivia 3 times, Nicaragua twice, Peru, Ecuador twice, and Honduras, but not against Paraguay after the impeachment of Lugo. And again, as I mentioned before, it seems that corruption is more the basis for many of these changes than violations of human rights. So one example is in 2009, when the Honduran army ousted President Manuel Zelaya on orders from the Supreme Court, supported by the Honduran Congress, the Attorney General, and much of the population. Zelaya, who had allied his government with Hugo Chávez's ALBA movement, was planning to rewrite the Constitution to remain in power. And so he called for a referendum that the Supreme Court said was illegal. The problem was the Constitution had no impeachment provisions, so there was no legal way to get rid of him. So the Supreme Court ordered him to be arrested. The coup was problematic under Honduran law and condemned by the United Nations, the OAS, and the European Union. On July 5th, 2009, by acclamation of all member states of the Special General Assembly of the OAS, the Secretary General was ordered to reinforce all diplomatic initiatives and promote other initiatives for the restoration of democracy and the rule of law in Honduras and the reinstatement of Zelaya as president. Furthermore, no such initiative would imply recognition of the regime that emerged from this interruption of the constitutional order. It also reaffirmed that Honduras must continue to fulfill its obligations as a member of the organization, in particular with regard to human rights, and that the Inter-American Commission should continue to take all necessary measures to protect and defend human rights and fundamental freedoms. There was later a general election that some candidates claimed was impossible to be fair and refused to take part. Mercosur also claimed that the elections were fraudulent. Other actors, including the United States, recognized the election as legitimate. The Commission documented massive cases of violations that occurred in the context of the coup d'etat and granted precautionary measures to save the lives of hundreds of persons. They also reported on the arbitrary declaration of a state of emergency, the disproportionate use of force against public demonstrations, and arbitrary detention of thousands of persons, among others, human rights defenders. The Commission also conducted several in loco visits to monitor the human rights situation in the country. The Honduras returned to civilian rule, and in December of 2014, the Commission undertook another in loco visit to the country in the process of reestablishing a democratic institutional framework in Honduras, one that required an effort by all countries in the region and all authorities in the country. The Commission documented problems of impunity, of violence, of corruption, and organized crime, and expressed concern over the intervention of the armed forces in many different state spheres and functions. Again, it expressed concern over the murder of many human rights defenders. Civil society organizations then opposed the return of Honduras to the OAS, asserting that democracy and respect for human rights were not yet present in the country. Nonetheless, the OAS voted to let Honduras return. In contrast to the situation in Honduras and the responsive OAS actions were the events that took place in Paraguay the same year. The House of Representatives of the Paraguayan Congress decided on June 12, 2012, to initiate an impeachment process against President Lugo. The following day, the Senate voted for his removal from office, 39 votes in favor, 4 against, and 2 members absent. The resolution on the procedure to be followed, which was approved by the Senate, established that Lugo could present his defense the following day for 2 hours. According to the request, the representatives of President Lugo said he needed more time to prepare his defense, but that was rejected. The Commission considered that the speed of the impeachment process was unacceptable, being highly questionable that it could be done within 24 hours while respecting the due process guarantees for an impartial trial. The Permanent Council held a special meeting to review the situation and proposed that the Secretary General conduct a visit to the country to collect information from all branches of government and non-state actors and report back. The President of the Secretary General, Jose Miguel Insulza, recommended not suspending Paraguay from the OAS, concluding there was no coup and that the upcoming election should go forward as planned. So in this case, because the constitutional procedures were followed to the letter, not in spirit, there was no recommendation for suspending Paraguay. Although the opinion in Paraguay was that the charges against Lugo were trumped up based on allegations of sexual misconduct, not anything he had done in office, and that it was really more about how he favored the indigenous people in Paraguay in preference to the majority. Nonetheless, it went on. So in my paper, I talk about a lot of the historical political theory that has supported the idea of a legitimate or a legal coup. I skipped over that now out of interest of time. But many commentators have discussed what they feel are the preconditions to a legitimate coup. There, of course, have been nonviolent means used, such as demonstrations, marches, strikes, boycotts, sit-ins, occupations, and civil disobedience. Remaining peaceful, of course, helps to have uprisings grow as more people are willing to join nonviolent actions. And most people see that it has more legitimate than less risky and more attractive means of violent actions. The number of participants is positively correlated with the success of nonviolent campaigns. Those that mobilize at least 5% of the population rarely fails. The legitimacy can also come from the fact that other institutional means have been tried but are not available or are not effective at a particular time. In Guatemala in 2015, protests had the clear objective of immediately removing from power people involved in a massive corruption scandal and bringing them to court. Specific successes were achieved when the vice president, followed by government ministers, resigned, and eventually the president also did. Winning external support was extremely helpful. In Guatemala, the UN-established International Commission Against Impunity uncovered massive fraud in the highest echelons of government, and the authority of CICIG provided an important legitimacy cover for the powerful civic uprising, including demands to oust and change the corrupt politicians. The goal of the political struggle should be to restore normal democratic processes and institutions. The reasons for an uprising cannot be trivial or transient. Extraordinary circumstances must justify extra-constitutional measures. Most people rise up because the seriousness of human rights violations by the ruling elite have demonstrated the urgency of counteraction that traditional opposition cannot deliver, and existing institutional measures have undermined or proved inadequate. So I will stop there and turn it over to Alexandra.
Well, I begin by thanking Jerry for inviting me, and I'm very honored to be on this panel with Dinah and Helena. And I'll be talking about populism in Latin America. As was noted yesterday, Latin America has been home to some of the most iconic populist regimes of recent history. So much so that it's a governmental form, or a form of doing politics, rather, that has been particularly associated with the region. The regimes of Juan Perón of Argentina and Getulio Vargas in Brazil were sort of the iconic populist presidencies. But then more recent experience, we've had the neoliberal presidencies of Menem, Fujimori, and, as Helena will argue, Uribe, and then on the leftist populist side, Chavez, Morales, and Correa. So this is a region that has a long experience with populist politics. It's also a region, however, that has a long-standing and well-established, if always contested, human rights system. The Inter-American System, which is created through the Organization of American States, modeled originally on the European system. It includes a commission that reviews the performance of all the OAS member states, and also a human rights court based in Costa Rica, which has jurisdiction over 20 Latin American and Caribbean states. And then further, the International Criminal Court has been engaged in the region ever since it opened a preliminary examination in Colombia in 2005. So it's an interesting region to look at if you want to examine the relationship and the interaction between populism and human rights. So today what I'll be doing in my comments is looking at three ways in which the interaction between populist movements and human rights has taken place in the region. And my claim is not that these are exhaustive. There is a long history of the two things living side by side in the region. But these are three that I would like to point out as particularly interesting. And before beginning, I do want to say that I'll be using a definition of populism that doesn't assume that human rights and populism are inimical, and rather cast populism not as a regime type, but as a style or strategy for doing politics. So a political means that can be taken by both challengers and incumbents, and used to pursue a wide variety of social, economic, and political goals, with certain features. So it is usually a movement that's headed by a charismatic leader who seeks to exercise power in an unmediated manner, bypassing institutional paths that precede him. This is a leader who would claim to represent those who have been excluded from politics, echoing the definition used by Peter Hall yesterday, and who promises to rescue the country or the people or the us from some sort of a threat. And this definition has the virtue that it uncouples populism from a particular political agenda, which I think Helena's paper will show is very important to do in Latin America. So turning to the three types of engagement with populism, with human rights, I'll start with the one that I think is most counterintuitive, which is the moments that populism uses human rights to advance its own cause. So one of the ironic twists of the Colombian peace process is that the right-wing opponents of the peace accord have appropriated the human rights movement's anti-impunity discourse, which has historically been associated with the left, but is now being used by the right. And as Helena, and this movement is headed by Alvaro Uribe, the former president of Colombia, who, as Helena will argue, had many populist features in his governing style. And during his presidency, he was not particularly enamored of the Inter-American system or the ICC, both of which he viewed as threats to his own, liberty. But then as the successor of a president began to negotiate the peace, the Uribistas began to use human rights law and discourse to oppose the deal. The 2016 accord, they argue, is too lenient on the former FARC members, allowing them to avoid prison time for atrocity crimes. They cite frequently to the ICC and the Inter-American system throughout their engagement with the peace process, using it to undermine the legitimacy of the negotiated accord. At one level, Uribe's human rights turn is a sign of the importance that this human rights law and the human rights international institutions have in Colombia. So even this instrumental embrace of an ideal can be proof of its importance. But I would also argue that the campaign itself had the result of increasing the importance of these international human rights courts in the negotiation of the Colombian peace process. It's through the right-wing Uribista opposition that the IC and the Inter-American Court were able to take on the level of importance that they did in the debates, arguments. There were challenges before the Constitutional Court, which brought in the ICC and the Rome Statute of the Inter-American Court jurisprudence, and the arguments even in Congress related to the passing of peace-related laws. All the legislation that the Congress has had to pass through has had to be framed by the representatives in the language often of human rights and of the Rome Statute and of the American Convention. So this shows it's an example of a populist movement cohabiting with human rights and perhaps even enhancing its importance in a particular political process. And there's unique aspects to the Colombian story, but I don't think Uribe is the only movement. The Kirchners in Argentina were very aligned with anti-impunity politics in Argentina, very close to the Madres de la Plaza de Mayo, and fostering an environment in which the courts prosecute. Argentina is now the country that has prosecuted most of the crimes of the former dictatorship in the Americas. So it is a dynamic that can take place beyond the Colombian case. The second type of engagement that I want to talk about, I called in this thought piece Bolivar and populism, by which term I refer to the populist presidency of Chavez, but also to some extent Correa and Morales. The consolidation of power via populism in Venezuela the way it takes place is amazingly similar to the way that it takes place in Hungary and Poland. The villainization of elites as corrupt, which many of them actually were, many of the institutions were corrupt, and the villainization of these elites as puppets of U.S. imperialism, the hollowing out or outright takeover of the anti-majoritarian institutions like the judiciary, crackdown on freedom of expression of private media, coupled with a obsessive use of media as a direct, unmediated form of communication with the people. Chavez was really the first Twitter presidency, surprising everyone that he could actually be concise because he's known as a very verbose president, and even using Twitter as a form of foreign relations with lots of exclamation points. So there's many ways in which the Venezuelan story resonates, especially with the Eastern European examples, including an attack on the inter-American system, which in many ways resembles the Hungarian approach to the European Court of Human Rights. Chavez consistently began to denounce the inter-American system of human rights as a tool of the United States due to the fact that the U.S. participates in the OAS but hasn't submitted to the jurisdiction of the court. So it gets to have a say in how things are run, but it doesn't submit its own country to the court. Now, all of these complaints by Chavez began once the Venezuelan cases against Chavez reached the system. He argued that the court and commission were biased and undermining their legitimacy. His own Supreme Court, which was packed with supporters, attacked the Inter-American Court as stepping beyond the American Convention and called on the government to withdraw from the court. And in 2012, he made good on an earlier promise and actually denounced the American Convention and withdrew Venezuela from the Inter-American Court. This is a severe blow to the Inter-American system, and it has made it particularly ineffective in the current unraveling of Venezuela and the human rights crisis that exists there now. It's been rendered particularly mute. So this is a case perhaps more along the lines of what we'd expect, in which populism works against human rights and was inimical in the way that we might fear. I do think, however, it's interesting to note differences between the Boliviaran experience and the classic populist of Latin America and perhaps the European nationalist populist, because these administrations were always very internationalist in their orientation. They were always outwardly engaged, and Chavez saw himself as a regional leader interested in exporting social solidarity and his economic model. His foreign diplomacy, even as it undermined existing international organizations, also sought to create new ones and successfully led the creation of UNASUR, the Union of South American Nations, and another looser alliance called the Boliviaran Alliance for the Peoples of Our America. Correa and he always spoke of creating human rights institutions within UNASUR and also ALBA. And Correa, the Ecuadorian president, who was much along a crony of Chavez, also had an interesting foreign diplomacy vis-a-vis human rights, in which he criticized the Inter-American system but managed to put an Ecuadorian judge on the Inter-American Court, and also became a strong voice in favor of creating a regional criminal court focused on corruption through UNASUR, which is a project that didn't get too much movement before the end of his term, but it will be interesting to see if, given the current circumstances in Latin America, anything happens on that front. Ecuador's new institution was very innovative in its rights provisions, including famously the first constitution to include a right of Mother Earth, or Pachamama. And these are ideas that have spread in the region, arguably even influencing the Inter-American system. So even in these populists who attacked and undermined the Inter-American system, we also see that for them, human rights could at times prove to be a useful discourse. The third example that I want to talk about, and in the brief piece that I handed out, I discussed the Dominican Republic and the violation of the rights of Dominicans of Haitian descent and Haitian immigrants with highly repressive measures. And then the DR has embarked on its own legally suspect effort to elude the Inter-American system, something actually that Dinah and I wrote about. But due to what I want to focus on instead here is another dynamic, a third way in which populism may interact or will interact with human rights in the region, and that has to do with the role of the United States. So populism as such is not within Latin America the biggest problem right now, and it's not a time of particular resurgence of populism yet, though perhaps there are some conditions in place. But the leftist populists in particular seem to have receded. But a feature of the regional systems that has perhaps been under-theorized in the more institutionalist literature is how much they depend on the Pax Americana, which was essential to their emergence. And there's a question of what happens now. The role of the U.S. is particularly key in our hemisphere. The U.S. is actually part of the OAS and the American human rights system. Of course, the U.S. has historically had a lot of influence in the region. It's true that since 9/11, there's been a time of benign neglect, which at least some Latin Americans think might be a good thing. And during that time of neglect, the inter-American system has continued to deepen ties with national legal systems and different audiences within the region. But that benign neglect is different from what Stephen Pomper discussed yesterday, that we now have a president that makes light of and even commends human rights violations and sends signals that, while seemingly flippant and not thought through, will likely have an important impact in Latin America. So in other words, I think the greatest populist threat to the inter-American human rights system is not from populisms that might pop up in Latin America, but rather the U.S.'s turn inward and its current presidency's lack of emphasis on human rights, so that pulling out or ignoring the system will likely have very few reputational costs in this new era. And I would add to that the fact that this is increasingly a year of uncertainty in Latin America. There's 4 upcoming elections in Colombia, Venezuela, Mexico, and Peru. And Brazil, of course, is embroiled in a corruption scandal. And now it seems that Peru might have an election. The president renounced 2 days ago, again due to a corruption scandal. And in closing, it's interesting to note that this corruption, which seems to be the thematic concern now in Latin America, is something that the human rights system has. There's no transnational movement that's a rights-based movement that's putting this before the inter-American system. So it's something in which so far the system remains removed and mute.
Thank you. So I also wanted to start out by thanking the organizers. It's an honor to be in this panel. I actually wanted to start with a comment that Jamie made in the past panel, which is about that populism sometimes has positive effects. And I think that both in the cases of Venezuela, the 2 countries I'm going to talk about, which are Venezuela and Colombia, in the case of Venezuela, initially many defended the idea that there was popular democracy. There was this idea that people would, in neighborhoods, in other places, be very involved politically. And in the case of Colombia, there was also a lot of participation of people who were generally not able to participate because of the conditions of the civil war. But I'm not interested in that aspect of populism. I am actually interested in the coupling of populism with authoritarianism. And that is what I'm going to concentrate my presentation. So the aim of this presentation will be to argue that, at least in the case of 2 ideologically opposing leaders in Latin America, Chavez on the left on one hand and Alvaro Uribe on the right on the other, they shared what I call, in the short notes that I sent, the draft, something that I call the legal architecture. So there are certain specific moves that are related to law that both leaders use. And in a way, I'm very interested in the fact that populist/authoritarian regimes are not characterized by lawlessness, which is somewhat of a paradox. Law is needed for a range of things in society, and so the turn to law is what interests me. And so I'm going to describe 3 very particular uses of law that were shared by both leaders. So the first one is the idea of direct democracy. So turning to referendums to reform the Constitution, to ask the people for their opinion specifically on some issues. A marked preference for executive style of legislation, either through a temporary permission granted by Congress or through classical administrative law regulation, and an augmented exercise of criminal law in order to discipline the opposition. So those are the 3 moves that I'm going to describe. And why do I think that unveiling the legal architecture is relevant? So I think, on the one hand, it will sharpen our alarms about modes of exercising power by populists, and also to explore avenues of resistance. Then a second reason why I think this is very important is to understand who embodies the opposition in the form of checks and balances, and how that these leaders are trying to avoid. So who is where? So who is, for example, in the judiciary, who is in Congress? Where are the places that the leaders are trying to avoid, and they try to avoid it through legal mechanisms, not through, pure violence, but permeated by law. And finally, I think that understanding the uses of law also allows us to flesh out in a detailed fashion the diverse political actors who are struggling for power or lack of it in a specific populist authoritarian regime. So first, a brief description of both Álvaro Uribe, the right-wing former president of Colombia, and Hugo Chavez in the case of Venezuela. They like to present themselves as men of the people. But it's really interesting. So they had it in Uribe had it in his agenda, Chavez said it constantly, but what the people meant was slightly different for each one. So in Chavez's case, the people were the classes who had been disenfranchised, even at times in which Venezuela was a very prosperous country. So people who had not seen the results of the oil boom in some way, and that had been excluded economically and politically. In the case of Uribe, interestingly, he talked a lot about the middle class. So both the middle class and the aspiring middle class, the people who, one of the quotes that I include is, he said, "I want a country that is characterized by a vibrant middle class." But in addition to that, and this is a very interesting part of his whole discourse, he was also wanted to picture himself as a peasant or attuned with peasant life, and also from the region. So he says in his political program something like, I want to represent, the fact that I'm a peasant has made me fall in love or be enamored of Colombian regions. So he had like this mixture between catering to the middle class, but at the same time also trying to show, a costume of being very, a campesino lifestyle. And he also had a lot of celebration of the fact that he wasn't from Bogota, but from Antioquia, a region in Colombia. Now, now I go to the legal architecture. So the first point is direct democracy. And there are many examples of both leaders trying to, of at least two in the case of Uribe and others in the case of Chavez, of asking the people for their opinion on constitutional reform. So Chavez had a famous referendum, which he lost, in which he wanted to abolish presidential term limits, expand Social Security benefits to workers in the informal economy, end the autonomy of the central bank, prohibit large land estates, and allowing the state, so this was included in the referendum, allowing the state to provisionally occupy property earmarked for expropriation before the courts ruled. He wanted to, in this same referendum, reorganize the country's administrative districts and allow the president to control elected state governors. So even elected state governors had to be accountable to the president, reduce the maximum working week from 44 hours to 36. I mean, the list goes, reduce voting age, the list goes on and on. Uribe did the same thing. When he got to power, he had promised that he would do a referendum against corruption. And the referendum originally proposed had a range of questions, including reducing the size of Congress, making Congress just one chamber and not two, diminishing legislators' wages, placing a cap on pensions and salaries of Congress members. So clearly, actually, opposing the legislature as the source of most corruption. In a way, this was also paving the way for his power grabbing. freezing public spending for 2 years. That it had a question about preventing the use of drugs in young people. I mean, it had a long list of issues. That referendum didn't pass either, but I think that what is interesting here is the parallel that there were a lot of detailed public policy choices that were being presented directly to the population so that they would decide theoretically with no intervention from representative democracy. Now, so the second characteristic is the use of executive power. And interestingly, at the beginning of both terms, they didn't use pure executive power that much because they dominated Congress. I mean, some forms of domination over Congress. So they were able to use temporary powers in order to legislate a range of things. So the Bolivarian Constitution of 1999, introduced the figure of leyes habilitantes, habilitating laws, which enabled the National Assembly to delegate on the president's lawmaking powers. And during his presidency, Chavez obtained it 4 times. And this produced 250 laws in total. And the amount of issues that were dealt with directly by these leyes habilitantes was enormous in terms of scope. I mentioned several things that are there. So oil, rural development, the functioning of the central bank. Uribe, on his side, used the state of internal unrest 4 days into his term, and it included a range of topics: a new tax on assets of wealthy Colombians, the design of special rehabilitation and consolidation zones in which military commanders were granted powers to search, arrest, and intercept communications without judicial order, the identification of the people who inhabited in these areas in a base, and the requirement that foreign journalists request permission in order to enter these zones. Now, part of this was struck down by the Constitutional Court, but the spirit of using executive power in this form is the same. Then the last point are the uses and abuses of criminal law. Chavez reformed Venezuela's media laws in order to incorporate the vague term social responsibility of the media. And going against the social responsibility of the media could be penalized by time in prison. In addition, in 2011, Chavez criminalized several banking practices and described economic crimes as crimes against humanity. So this turn to criminal law was very prevalent. Uribe also had a turn to criminal law, a little bit less successful, but he tried to pass an anti-terrorist statute strengthening the punishment and criminal law power to carry out his landmark government policy, which was called Seguridad Democrática. The law emphasized the need for citizens to support the state-sponsored security forces and set out to create or strengthen a network of 1 million citizens informants to provide intelligence. Along these lines, he proposed that Mondays be set aside as El Día de la Recompensa, or Day of Reward, where the government would pay citizens who in the previous week had helped the state-sponsored security forces to prevent a terrorist act or capture a suspect. So very scary stuff. I would like to end by saying that by unveiling the legal architecture of populism, I have hoped to sketch out the ways in which different tools were deployed in order to produce arguments of legitimacy. So the link with legitimacy is very important here. And it was geared towards providing an aura of neutrality in the selection of winners as well as losers in each country. Through the legal architecture, Uribe was able to legitimize his support of the landed elite, the industrialists, as well as the financial sector, and the most radical wing of the Conservative Party, which is the strand that is to the right, both in terms of the economic agenda, but also the social agenda. The losers of his policies were paradoxically the liberals, even though he was very much termed as a neoliberal president, but he was very particular about the groups he privileged. So in a way, one could say that he affected the equality of the market. And of course, center and center-left members of the Liberal Party. Chavez, on the other hand, privileged the military, and at least initially, some have argued, the marginal classes. His model produced many losers who were the economic elites that were there beforehand, the state bureaucracy. So there was a huge firing of state bureaucracy at the time, and the existing legal institutions through, for example, court backing that Alex mentioned. So thank you very much.
Thank you. So before I open up to the questions on the floor, I was wondering if I could turn to our esteemed panelists and to give you all a chance to react and respond to the contents of what was shared here on this panel.
Yes. I'd like to comment on something Alex pointed out in her paper, and that was about the effort to undermine the international institutions by packing them with supporters of the governments. That happened more than once in the inter-American system in recent years. The president of Ecuador tried to propose a new executive secretary who was clearly his personal attorney. And when he didn't make the short list, they went to the Secretary General of the OAS and tried to convince him that the commission could not draw up the short list on its own motion. So in addition to getting somebody on the court, they've tried to get the executive secretary, they've tried to get the members on the commission. So it's a way of not just packing the domestic institutions, but also packing the international institutions in a way that would make them more favorable to the governments.
No.
So I actually have 2 points. One of them is something very interesting that Dinah said about the fact that they applied the law literally. And so I was really interested in that because it's using the law even despite itself. So I was wondering if you could say a little more about that.
Yes, in the case of Paraguay, they followed the procedures laid out in the Constitution to impeach the president, but they violated due process rights by only giving them 24 hours to respond and then only giving him 2 hours to actually speak. And so despite the fact that the procedures were followed, the Constitution was rather sketchy on the details, and they filled in the details the way that worked for them.
And for Alex, I was wondering, so this really interesting idea about deploying human rights for, like, the unintended consequences of deploying human rights. I was wondering if there, for example, in other cases, not in the case of the Colombian peace process, but has it been used, like, could it be used in the Dominican Republic, or so that argument that if we don't do this, it's in violation of human rights, or if we don't go on that side?
I think, yeah, there's examples of, and I think it's something that needs further research, of courts around the region using human rights in sort of illiberal decisions. And one of the most egregious examples would be the Dominican Republic Constitutional Court in its judgment when it stripped retroactively citizens of their citizenry due to their alleged Haitian descent. They did cite to the Inter-American system and sort of use. In fact, that court has frequently cited to the Inter-American court. Only later did that same court decide that actually it wasn't under the jurisdiction of the Inter-American Court. But I think there's many moments in which even the Venezuelan Supreme Court will cite to the American Convention more than to the Inter-American Court. Yes, the answer is yes.
Great. Without further ado, I would now like to turn it over to the floor for questions. Please note that this session is recorded, so if you don't want to appear on camera, reserve your questions to ask our esteemed panelists offline. We have 2 microphones that are running around, so please be sure to introduce yourself and your affiliations. Yeah, we've got one there.
Douglas Johnson, the Carr Center for Human Rights. I wonder if you could speak to, I would call it the failure of the human rights community in Latin America to address what was happening in Venezuela. And I thought Helena's comparison of 2 populist movements, left and right, was really interesting. My impression was Latin American human rights groups critiqued Uribe's approach, but largely, with the exception of De Justicia, largely gave a pass to Chavez because of what they called the inclusionary nature of the Venezuelan regime. I wonder if you could speak to that aspect of the link of human rights organizations to leftist populism, and what are the long-term implications of that for credibility of the human rights movement in Latin America?
Well, I think part of it goes back to the point that Alex made at the end of her paper about the role of the United States, because the U.S. has always had a favorable immigration policy toward leftist regimes and a less favorable policy toward rightist regimes. There was a famous cartoon during the Reagan administration of somebody going into a Chilean prison where there's a guy shackled to the wall, and he introduces himself and says, "Hi, I'm the new human rights officer for the U.S." And he just sort of then walks out. But I think the U.S. has oil at the base of some of its decision-making on Venezuela, as do other countries in the region. There's also the distinction between resistance coming from internally and resistance from external sources. There was a very good example with Fujimori being extradited to stand trial in Peru, where Chile cooperated with the international efforts, but there are also times in which the calls for regime change have produced a very negative reaction.
I would add that this speaks, I believe, to the limits of what the human rights systems can do in face of this sort of systematic legal dismantling of their liberal institutions. It seems within Venezuela there were many attempts to bring cases before the Inter-American system having to do exactly with the policies that were causing democratic decay. Those cases went through the system, according to Chavez, more quickly than any other cases against any other governments, and that was one of the reasons he put in his letters for the denunciation. But they did go through quickly by Inter-American standards. They led to judgments that then led Venezuela to denounce. So there was a way in which the activists within Venezuela, there's a case, there's a Leopoldo Lopez case, there's a case by Alan Carillas Brewer before the Inter-American system. And really, they had very little impact on the situation. So at some level, it does speak to some of the legal limits of the regional human rights system in face of that kind of situation.
Just to reply, neither question has hit on what I was trying to ask, and so let me be more explicit, because I know the human rights community better in Uruguay and Argentina, and in those situations, like CELS, the leading human rights group, refused to even consider the civil political rights violations of the Chavez regime, giving it not just a pass, but a certain support because of what they perceived to be a new interest in economic, social, cultural rights, and therefore a primacy of those over the civil political rights. CELS never made a denouncement of the Lopez case or the rape of the lawyer or the judge or any of these other issues. And I found that shocking, that the human rights community appeared to be much more partisan in that situation than one would have expected.
Hello, I'm Jimena Reyes, a visiting fellow at the Human Rights Program, but I'm also director for Latin America at the International Federation for Human Rights, and CELS is a member of the International Federation for Human Rights. So I wanted to address this question because it is a real challenge. And it's not only a challenge for Latin America, also for the US human rights movement. Many of them having learned about human rights in revolutions or attempt of revolution in Latin America in the 70s. So yes, historically, there is a link of the human rights movement in Latin America and elsewhere with what is seen as progressive, maybe leftist movement. And personally, in the last 15 years, I have seen a very interesting evolution within my organization that of which are members more than 45 human rights NGOs in Latin America, in the sense that it is true, one has to acknowledge that 10 years ago, when Chavez got into power, but when Evo Morales got into power, when Correa got into power, there was a reluctance to criticize those regimes. And maybe it was a mistake. But the change I want to address is that today, you will not find a human rights NGO in Ecuador who is not ready to criticize Correa or Lenin, because they have realized that what was a hope has become populist or authoritarian movement. And if you look at the website of the CELS, in the last 3 years, there are statements against Venezuela. And I think it's, but I'm not saying that it's not an issue, but today there's a real evolution, and we used to have there are discussions, strong discussions, but right now, really, I see a very, very little minorities of NGOs, organizations that are still very linked to communisms that don't want to criticize, for example, Maduro. And something that I think it's also interesting to understand why it was such a challenge is that the social movement in Colombia, I'm Colombian, in Latin America, and the human rights NGOs in Latin America also come from a social particular background, except maybe startup NGOs like the Justicia that don't. And in that sense, when you have members that owe their university education to Cuba, well, it takes time to realize that you do have to criticize Cuba.
Thank you, Helena. Was there a reaction from the panel with regards to what has been raised? Or? No.
Well, one thing I might, when you asked this question the second time, I understood more. It made me think of Ruth's panel yesterday when she was talking about the absence of institutional, silence of the human rights systems before social and economic inequality perhaps makes the situation, makes them a little less able to act in face of a situation like Venezuela, right, where there is this authoritarianism on the rise, but at the same time, these socioeconomic rights are or at least, for a while during the Venezuelan regime, some of the social indicators looked much better than they had before. And that was something that the human rights institutions had nothing to say about. And so perhaps that also is something to consider when we think about what does this all tell us, as Jeremy Waldron was pushing us to say about conceptualization of human rights. And that was Ruth's question, right? Why are these institutions so silent before some of the big issues like social inequality?
Yes, the question for her.
Hi, Yasir Latif Hamdani. I'm a visiting fellow from Pakistan. I'm a visiting fellow with the Human Rights Program. My question, and I might have heard this, might have gotten it wrong altogether, and that might not have been the case. But did I hear Dinah speak about or say that the U.S. favors or is softer on leftist-leaning populists as opposed to,
the other way around.
The other way around. Okay.
Other way around.
All right. I just, that is, so my question essentially, so I wanted to clarify that because I think that's what I heard. My question essentially is this: do you feel, when you're looking at these models around the world, do you feel there should be a certain ordering of priorities? For example, are you going to support a military authoritarian regime versus a populist regime that might be something that the US might not agree with, or the human rights might have an issue with, or might be corrupt for that matter to a certain extent? Do you believe that the idea of having civilian democracy come into power over the deep state, is that an important ordering priority, or is it not? So, thank you.
Well, if I look around the world today and say, what do I think the biggest human rights problem is in terms of a country, I'd probably pick Syria, just because of the nature and scope of the violations going on there. But other people can disagree and have their own priorities. I'm not sure I got the sense of the question.
So essentially what I'm asking is where you have, so for example, I'll give you an example. What is on my mind essentially is this idea, and I've been, ever since I've come to the US for this fellowship, I've had discussions with a lot of people. In Pakistan, for example, we see an overreach by the judiciary, which is, after all, a counter-majoritarian institution. And that overreach seems to be driven by elements within the deep state. So I'm sure you're not as familiar with the Pakistani context as one is, being from there. So I just wonder if that is something. So when you're talking about rule of law and you're talking about counter-majoritarian institutions, for example, such as civil society, such as the Supreme Court, do you feel that civilian democracy as opposed to civilian rule as opposed to deep state or military authoritarianism or military behind the scenes is something that you would order above other considerations such as human rights or corruption for that matter?
Well, I don't think you can separate rule of law from human rights from the democratic order in some way. And so if you've got the kinds of checks and balances that you were talking about in your presentation, then I think every institution has to have some accountability, including the military, including the courts. And there is a process for removing judges in most countries that I know of. So, if the judges are overreaching, there's a process to get rid of them, just as there's a process to get rid of members of Congress or the executive. So I don't necessarily favor one over the other. I just see them as inextricably linked.
Yes, gentleman in the far end.
Thank you so much. I think I'm going to take issue with Douglas here. Most of the people who are involved in the human rights are people who have been in the left and who have been, at times, historically victimized by the systems in place. And it's questionable how we're going to get into a transition where some of the rights of the real people are going to be up against the people who have been empowered all the times, and try to get that balance across. And I'm saying that, because, I wonder if there is a balance somewhere in Latin America, a country that has come up to get that balance where you may have had people who are in the left who are now advocating on behalf of all of the people in the country, and be able to be successful in that, to provide some type of model to the rest of Latin America or something like that. I know that you guys are from different places and all, but is there a country out there that has gotten that balance?
Would you say Costa Rica?
So, but the balance
Yeah, I'm not sure what the balance
So can you repeat what the balance is?
No, is there a country in Latin America right now that looks like a shiny place in terms of human rights, that has gotten that balance between advocating for the people that have been historically deprived of their rights versus the people who have been in control and have deprived those people of their rights, that have gotten that balance these days? One country.
So you say Costa Rica?
That's the closest one I can think of.
It's a difficult question. I actually don't have an answer to it. But I did want to say something about the initial part of your comment, which is that human rights have been typically or traditionally on the left. And I think that was part of the first part of her presentation, which I found really interesting, and I actually wrote about this, which is the shift that the right has had. So now the right is arguing human rights all the time. So Uribe is very interesting in that, which is that when he did the peace process with the paramilitary, he would call the human rights on the, many institutions of human rights saying, oh, you're too formalist about human rights. You have to be flexible because we're interested in peace. Now, 8 years later, he was all human rights. We have to apply them. What is this? Colombia has subscribed these treaties where we're in violation of human rights. So the right actually now more and more for strategic reasons is, inhabiting the language of human rights, I would say.
Anything to add from Dinah or Alexandra to that? No? If that's the case, yes.
Thank you. So I was interested in the analysis by Professor Alviar of what you called legal architecture, and in particular in your mentioning of the use of direct democracy, I think by Uribe. Because I think it raises a more general issue about relationship between direct democracy and populism. We certainly shouldn't force ourselves to a position that that the use of direct democracy in itself is an indication of populism. It's not. Direct democracy may be a perfectly legitimate part of liberal democracy. So these are only some uses. Maybe something will depend here on the frequency, but basically much will depend on what sort of questions are put. And typically for populists, they use disingenuous questions rather than real questions. So they use plebiscites or referenda in order to validate and add legitimacy to the decisions already taken. And the questions are usually articulated in a way that there's only one answer possible. And here a master in that type of uses of referenda or plebiscites for populist purposes is Viktor Orban, who, for instance, would ask people, do you believe that the government has a role in protecting the country against uncontrolled immigrants who may bring violence, blah, 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 blah. And, and there is no way that he will not get over 90% responses yes. So what I'm interested, but you gave an example of a referendum, and there was a large number of policy questions. So was it this sort of real type of legitimate referendum, or was it disingenuous in the way I described it?
So thank you very much for your question. I actually agree with you in the sense that not all referendum is bad. But the interesting thing when I was doing the research for the notes, the draft that I sent, was that there were many detailed questions about things that require a high level of sophistication, knowledge, etc., which begs the question of, well, that's why you have a representative democracy theoretically, because you're going to have people who have the knowledge, the time, the skills, etc. And in both cases, in both Uribe and Chavez, not even if you go into the disingenuous, not even if you have a suspicion about what their motives were. So let's bracket that for a second. The level of detail and the type of questions was just, they actually, from my perspective, they were betting on the fact that they were so popular as leaders that people would just answer yes, 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 because it's in favor of this person, not in terms of the content of what the questions were. So yes, I would answer that, yes.
We have one more questions. Okay, I'll first go to Professor Henry Steiner, and then followed by Richard, please.
Question of direct democracy has come up, and I'm wondering whether it's as prominent in Latin America as it's become in some way in this country. I think our present best example of direct democracy are polls, which are constant in being put to 1,001 uses. So a very important part of this use of direct democracy, or a more conventional one like a referendum, would be to initiate for the first time heard on earth a phrase, fake news. So, I mean, here it makes you really wonder about how to trust all the polls and what would happen with the referenda or other situations in Western states that do incorporate in their systems direct democracy, and whether this is turning out to be as massive a problem in Latin American countries as a form of pushing the populist program ahead, or indeed any other program.
Who would like to start?
Well, I come from a state that has referenda, and they've been misused repeatedly. So one of the questions I have is, who's asking the questions? Because so often we find that lobbyists have created referenda questions in California and disguised who they are, and they run these campaigns to get them adopted, and people later find out what a mistake they were. Going back to Prop 16, I think it was, that raised property taxes, it's destroyed the school system in California. So I think it's important to look at referenda in terms not only of what they're asking, but who's doing the asking, who's actually behind the questions being asked.
I don't know if you want to say something.
Do you have something to say? No, I think that the issue with polls is really, the link with polls is very interesting, because it's the same style of, it's the same, it could be looked at with the same lens, which is, it depends on how you're presenting the poll results also. It's going to make a huge difference. So, for example, as Alex was saying, this year is an election year in Colombia, and consistently they have been saying that the polls say that leftist former mayor of Bogota is going to win. And so everybody is panicking because they think that he's terrible. But when you look at the numbers, it's actually not true. I mean, he is, in some polls he's ahead, but actually what is ahead is people who are either undecided or say that they're not going to vote. So it depends on how you present the results of a poll. You're going to get different results for a specific question. So yes.
I guess I would mention the fact that the Colombian peace accord was put to a plebiscite in Colombia, and it actually failed the plebiscite. So there was a no vote, and it was a very, the analysis post-vote pointed to a lot of manipulation of news, a lot of fake news, especially by the Uribista right that started campaigning before the government, because the government really only started campaigning after the peace accord was signed, so they gave themselves a month. But they nonetheless overrode the vote, and so they went ahead and passed, revised the peace accord, and then submitted it to congressional vote. And in some ways, this is a stain that the current peace accord carries with it, right? The loss of this plebiscitary vote. It's something that continues to be part of the questioning of the peace accord.
Yeah, I really look forward to this panel, not only because it's an all-female panel, which is a great thing always to see, but also because Latin America in some ways is at the cutting edge. You've been there, done that. You have done populism ahead of a lot of us. What do you think are the lessons for the rest of the world? Because I think one of the consensus among us, at least yesterday, was what populism does is that whether right-wing or left-wing, they tend to destroy institutions over time because they create a cult of personality, whether it's Uribe or whether it's Hugo Chavez, it doesn't matter. So what is the lesson that Latin America shows us about what happens the day after populism, after populist regimes collapse? What is the reconstruction process? What is the tendency of the regimes that come after populist, if indeed certain parts of Latin America are in a post-populist kind of scenario? And the positive and negatives of that, of course, because I know in Chile, for instance, some of the more positive aspects of populism was passed on to a more centrist party. So not everything is bad, actually, after the populists come into power.
Who was the populist in Chile?
I always think
Bachelet?
the leftists who first came into power.
Bachelet?
Yeah, Bachelet, I was thinking. After Bachelet, you had the right, center-right, and they incorporated some of the good elements of the Bachelet administration, I would say.
Yeah, I guess I would question that characterization of Michelle Bachelet, but I think that if Argentina seems to point to the idea that there's a certain path dependency, paradoxically, right, of populism, and it seems to have been, ever since the Perón the first presidency, there's been a tendency for, what Guillermo O'Donnell, someone mentioned the paper, describes as delegative democracy, where there is no horizontal accountability, and it's just a sort of vertical accountability. So one lesson at least drawn from Argentina is that, that there is a danger of relapse, and it will be interesting to see what happens with Macri as his term unfolds.
Yes, so I would, this is a really interesting question, and I think that that's work in progress. That's what actually, because I do think that we have to become much more aware of what are the different forms that populism, how it's destroying the institutions along the way. So there are things that we are very aware of, like, packing the court or closing Congress or things, but maybe more nuance to what has been done and how it has been done, probably in order to establish like some safeguards in the system. So that more I would actually call, because that's what I do for a living, more research on not just the broad questions, but the specific details of how it was done. And I think that there's a little less of that. There has been more of the context or historical understanding of how it happened, what it happened, why it happened, but not like the different tools that were. So that's part of what I would be interested in. So I know it's a very frustrating answer, but that's...
I would agree with Alex, too, about the danger of backsliding. And it's not just Argentina. We see it now in Brazil as well, where the situation is becoming quite desperate. So I think there's, this question of eternal vigilance. keeping the international institutions strong enough to be able to step in and do something about what's happening in these countries.
Yes.
So fascinating panel, thanks to all of you. And I second Richard's comments about the centrality of Latin America, all these discussions. I wanted to ask for a little more elaboration, with apologies for my ignorance of some of the specifics of the Correa, Morales, and Uribe practices. So to what degree have these three, and I feel like I know the answer on Chavez, but maybe it's worth commenting, to what degree have these three, or maybe four, used a sort of populist trope that checks and balances specifically constitute unreasonable infringements on a kind of popular will, as opposed to what all executives do, which is, of course, push back against checks and balances. So this is getting a little academic, but...
Well, Correa certainly did. Correa invoked, I am the popular person. I am the one who represents the popular will. And he struck at newspapers in particular that issued editorials against him. He filed defamation suits, one for $5 million against a newspaper and its publisher for an editorial that was in the paper claiming that he was acting as in his private capacity in filing this lawsuit, and it was perfectly appropriate to do so because he wanted to uphold the integrity of the press. So he invoked that trope quite frequently.
Yeah, and this is very much the case in Venezuela, and I'm forgetting the name of the Spanish consultants who participated in advising the Venezuelan and Correa governments as they sort of developed their constitutional law philosophies. But they had a whole understanding of a much more, will of the people type of democratic constitutionalism. So it was not just. It's not. They weren't just saying these institutions are corrupt. They were sort of reinterpreting the role of judicial review and rights within a democracy.
So I would just add that, for example, Uribe tried to get re-elected for a third time, and part of his, discourse was it's what the people want, and in Congress, it has to do this because that's popular will. At the end, one must say that when the Constitutional Court said that it was impossible, he did, he could have done something differently, but he did. So this idea that it's like him against the other institutions, but also he had many instances and continues to have instances in which he either sues or is being sued because of issues that have to do with freedom of expression or issues like that.
I think we have time for one short question, so if there's anybody out there who would like to ask that.
Yes, Correa certainly wasn't the first populist president in Ecuador. Mm-hmm. I mean, there was Abdallah Bucaram, who was clearly elected on a populist platform. So some have speculated that this notion of populism in Latin America has some connection to the lack of established party systems or party politics within certain states. So, for example, in Ecuador, you have movements, parties, consolidating around a movement and around a particular leader, a former mayor, in Bucaram's case, or a former general, or a banker, or something like this, and then you have the consolidation of a movement, and ultimately that brings the person to power. I think Correa is a good example of that, where he created his own party, and I think this is the pattern that you see happening over and over again. So I'm just curious if you could speak to the relationship between the party system, the lack of sort of established dual party systems. Costa Rica was the one example of a country where there might be a balance, has a very long established dual party system. So if you could speak to that, please.
So we're getting to beyond my area of specialization with comparative democracy in Latin America, but I can say that that there is a lot of variation, I think, in the region, that you can't really generalize, and that Chile, like Costa Rica, is considered to be a consolidated democracy, and it's not a two-party system. It's a multi-parties. It's traditionally divided along three, sort of center, left, and right, and the different parties form two coalitions. So I think there's a lot of variation. At the same time, when I think of the Argentine parties, right, these are long-lasting parties. The Peronists have been around for a long time, but they do tend to be centered around a strong personality, right? Even if it's no longer Perón, they do tend to be personalistic. But I think there's a variation in the region.
But I think in the whole region, in addition to political parties, you have other institutions that have a great deal of power, like the military in some states or the Catholic Church in others. And in Mexico, you have essentially a one-party state. So it's very hard, as Alex said, to generalize for the whole hemisphere.
Well, on that note, can I get everybody to join me in thanking our esteemed panelists for answering the questions? I would also like to thank those of you who participated with questions as well. We're now going to break for lunch.